Hello, welcome to Legislative Report. I'm State Representative Kate Harper of the 61st District in Montgomery County. Currently, the Pennsylvania Constitution requires justices, judges, and justices of the peace to retire at the end of the year in which they turn 70. I've introduced a bill to change that age for judges to age 75. This change would require amending the Pennsylvania Constitution. But I believe that experience matters. Instead of forcing qualified, capable judges out at the age of 70, I think the Commonwealth should instead rely on the Judicial Conduct Board and the Court of Judicial Discipline to remove any judges of any age who are no longer capable of serving on the bench. On today's program, you'll see portions of a hearing on House Bill 79 held by the Judiciary Committee Subcommittee on Courts. I hope you'll take a few moments just to listen to the testimony that was gathered, because you, the voter, get to make the final choice at the ballot box.
I think we're prepared to begin with our witnesses, the first of which is Kate Harper, representative and the prime sponsor of House Bill 79. Thank you for being here. Thanks for your legislation, and you may proceed when you are ready.
Thank you very much, Chairman Grell, Acting Chairman Calderone. Thank you for those remarks. And members of the committee, we had a pretty long session week this week, so I appreciate all of your attendance here this morning. And interested audience members and the witnesses as well. I appreciate the ability to talk to you about my House Bill 79, which would affect a constitutional change to allow judges to serve to the end of the year in which they turn 75 instead of 70, as the current constitutional provision reads. This current provision has been in effect since 1968. 1968. There's people in the room who weren't born in 1968, okay? But I think many of us know that there have been many demographic changes in Pennsylvania and in our nation since that time. Not the least of which is, of course, that the life expectancy has advanced in that time from age 70 to 78. And it's no longer unusual, as per Chairman Calderone's remarks, to meet somebody who is living and working well into their 80s and 90s. Pennsylvania seems particularly blessed in that regard and has a large percentage of citizens in that demographic age group. For some of us who remember back to 1968, don't trust anyone over 30 was the mantra. Remember that? Okay, suddenly 75 doesn't seem as old as it did back in 1968, and retiring at 65 is coming to be viewed as retiring early. So my bill proposes moving the mandatory retirement age from 70 to 75 for judges. Other proposed legislation in the Senate would actually remove the age entirely. In other states, there is no maximum age at which one is allowed to serve as a judge, and other states still have retirement ages at 70, 72, 74, or 75. In Vermont, the hardy Vermonters are allowed to stay on the bench until age 90. The lawsuits, in fact, there are lawsuits, in fact, that are challenging the Commonwealth's mandatory retirement age of 70 as arbitrary or as a violation of laws prohibiting age discrimination. And these are all important things to keep in mind, but they're not the reason that I introduced the bill. For me, a person who has practiced law at least part-time for more than 30 years, I know and have seen many, many judges. I've practiced before judges in state courts in their 40s, 50s, and 60s, where when they reach age 70, they are allowed to be senior judges and continue in service. And they actually have to either retire or become senior judge. But I've also practiced in federal court where there are lifetime appointments, no upper limit. I've seen men and women in their courtrooms and in their communities, and I just have a hard time believing that on your 71st birthday, suddenly you're incompetent to continue as a judge. In fact, I think the opposite might be true. In his book, Outliers, that some of you have read, Malcolm Gladwell posits the theory that it takes 10,000 hours to master a subject. whether that subject is playing the violin or sinking a jump shot. And that's about 5 years if you're doing it full time, 5 days a week, 40 hours, okay? But think for a moment what it takes to master the role of a judge and what it means to have mastery in the field of judging. The job of a judge is very different from the job that we do as legislators. As legislators, we're called upon to write good laws, to advance civilization, to correct perceived wrongs in the current system, and be mindful of what our constituents would like us to do and what they expect. But at the end of the day, as we all know, it is not the most brilliant law that gets enacted, nor the most just, nor the cleverest law, as some of us find to our chagrin when we think we have a law that meets those criteria. In the end, it's simply the law that gets 102 votes in the House and 26 votes in the Senate. That's a very different job than being a judge. And I should say also one that the governor's willing to sign. A judge, by contrast, is sitting in judgment on a specific set of facts and specific individuals or businesses, and who is then tasked with applying the law to this specific set of facts. The judge doesn't write the law. He's supposed to know the law or look it up before he makes his decision, okay? But his decision applies to those people who stand in front of him in the courtroom, anxiously awaiting the decision. The judge has to make a decision that's based on specific people, specific testimony, specific evidence. The legislator's worried about the fate of the Commonwealth in general and his or her constituents in general. The judge is concerned about one citizen and what will happen to them as a result of the decision they make. But so it does seem to me that whether we're talking about a legislator or a judge, the nature and extent of the human experience matters. And if it were not so, a well-programmed computer could do either of our jobs. But it can't. Drill down a bit and think about these situations which judges deal with every day in the Commonwealth. In deciding the custody of children, let's say aged 4 and 6, would it not be helpful for the judge to have some experience with people of that age? In determining whether a son is protecting a mother from her own frailties, in minding her money for her, or in taking advantage of her in her frailty, would not some experience with a frail elderly parent be a useful thing for the decision maker in looking at those facts? In parsing a knotty question of title to real estate or just the mineral or other rights in real estate, wouldn't experience in handling those cases be a helpful thing in making a decision? Even in trying to persuade lawyers to settle a case, wouldn't experience with difficult personalities, and I say that as a former litigator myself, or even experience with the particular litigators who are in the room, be a useful thing in trying to get them to come to a resolution? For understanding veterans, isn't it a good idea to have a judge who's served in combat or understands combat to be able to judge their unique situations? I think the answer to all these questions is yes, and I think it means that experience matters in doing the job of judge. At my law firm, my senior partner, Tom Timoney, namesake for Timoney Knox, which is our law firm, practiced until a couple of weeks before his death in his 80s. He was not only the go-to guy in our law firm for trust and estates, which is what he was an expert in, having practiced for more than 50 years, but he was also the go-to guy for just about everything else. In other words, if you had a brother and a sister fighting over whether to pay for a headstone for mom's grave, Tom Timoney was the guy who would tell you how to get them to agree. He had spent 50 years practicing law, 50 years married to the same woman, 50 years raising 9 children, and he had a wealth of interpersonal experience that helped him make good judgments about what should be done. I think in the later years, lawyers like Tom Timoney have those experiences fermented so they become wisdom in practice. In my own home county, Judge Horace Davenport, the county's first black judge, was a master at settlement conferences. His percentage at settling cases was better than any other judge on our court, and he only left when the law required him to do that. And as a result, the court's backlog grew a little bit because he was not there to do his job. Now, I know that some people will worry that an increasing percentage of older judges, as an increasing percent of seniors, might be afflicted with conditions like Alzheimer's or dementia or other things that would affect their ability to be effective judges. However, I do not believe we need a hard and fast rule that bars everyone over the age of 70 from serving. That's why we have a Judicial Conduct Board, consisting of judges, lawyers, and citizens who can investigate complaints and accord judicial discipline. Each of these bodies deals with specific complaints, investigations, specific judges, and determines whether or not they should be on the bench. The current mandatory age of retirement at 70, by contrast, simply throws the baby out with the bathwater, ridding the court of wise older judges who may have become better with age, along with those whose abilities may have declined. As Rabbi Harold Kushner, author of many influential books, put it, we do ourselves a disservice when we make old age something to be feared. Life is not a resource to be used up. So the older we get, the less life we have. In fact, life is an accumulation of wisdom, love, experience, of people encountered, obstacles overcome. The longer we live, the more life we possess. House Bill 79 stands for the proposition that mere age alone is not a disqualifier if the human being selected as a judge is otherwise competent to be a judge. In fact, if we want wise and just judges making the right decisions for the individuals who stand in front of them, we just might learn to prize their extended experience and the wisdom that it brings. Thank you.
Powerful, powerful testimony. And I couldn't agree with you more. You know, just alluding back to, you were saying about veterans and whatnot. My federal judge in my office, retired federal judge, he was a fighter pilot in World War II, shot down over the Sea of Japan, and worked in the vineyards in the legal community for 30 years with the wealth of experience in cases that he's handled, and 25 years on the federal bench. So you're absolutely right. You know, and we set up all of these specialty courts around the state, and why should we throw that experience out? I'm just dumbfounded that we do that to some of our most experienced people. It's just like us in the legislature. You know, the more experience you get, the better you get at trying to get laws passed and correcting conditions within this Commonwealth. So I concur and I agree with you. Excellent testimony.
Thank you.
You offer a really compelling opening statement for your legislation. I'm a co-sponsor of it. I think we see examples of this not just in the judiciary, but maybe uniquely in the judiciary. But we see it in academia. I was a teacher before this, and the accumulation of experience in dealing with students. The professors I dealt with, those who were 70, were certainly qualified and even more qualified in many ways. We see it in industry also. You are not disqualified because you've hit the age of 70. In fact, the accumulation of your time and experience actually adds to what you can do in all areas of life, I think. It's probably a cultural problem we have, noting back to how we prize youth and we maybe forget to prize the wisdom and experience of age. Two questions. Number one, do you think this is more properly dealt with in the legislature rather than by the judicial branch? I know there is a case you mentioned.
Yeah, I've expected that question and decided that it was not my place to say whether it should be done here or there. Obviously, it's a constitutional provision. To change it in the Constitution, we have to go this route where we pass it in 2 successive sessions and then put it on the ballot and let the voters make the final call. I've also actually done some age discrimination work, and so I know some of the cases that have been filed by judges around the state actually deal with that, and I don't want to prejudge that issue without having the evidence of whatever they're offering in front of myself. So I absolutely think it's appropriate for us to address it. Whether or not it's also appropriate for them to address it is a question for a different court, literally.
Okay. And my other thought was, in preparing this legislation, did you take a look at the fiscal impact or impacts this could have?
You know, it's difficult to get at that. I have been told by some people that the fiscal impact of allowing a judge to serve is actually better because they don't start taking their pension right away, and you don't have to teach a new judge the ropes or fit out a new courtroom or do any of those things. I think that I'm not exactly sure how that plays into the pension. Some people say, well, you got to keep paying them for longer, but you'd be paying somebody anyway. So it may be a net positive, but I can't say that for sure.
Okay. Thanks very much.
Did you know that Violet Oakley was the first female artist to receive a large commission for artwork done in a United States Capitol building? In 1902, Joseph Houston, designer and architect for the 3rd Harrisburg Capitol building, commissioned Violet Oakley to paint murals for the governor's reception room. He believed that Oakley's contribution would add interest to the building and act as an encouragement of women of the state. Prior to beginning her work for the Capitol, Oakley set out to England to conduct research for her murals. Upon return, she decided to center her artwork on William Penn and the founding of Pennsylvania. Oakley made sure that Penn's ideals of justice and peace could be seen throughout her work. In 1906, she completed 13 murals titled The Founding of the State of Liberty Spiritual and was placed in sequential order around the governor's reception room. These murals were some of the first to be installed in the Capitol. When Edwin Austin Abbey, another artist for the Capitol, died in 1911, Oakley was offered another opportunity to create murals for the unfinished Senate and Supreme Court chambers. Her work on the Senate murals, including International Understanding, was completed by 1919. Oakley then completed the Supreme Court murals, including the Divine Law, by 1927. Oakley is said to be the principal artist for the Capitol, with a total of 43 murals on display. She remains one of the greatest muralists in the United States. Now you know.
Did you know that in the corridors in the first floor of the Capitol of Pennsylvania, there are nearly 400 individual mosaics? The idea for creating these intricate tiles was first suggested by Henry C. Mercer in 1902. A year later, he received the commission to prove 16,000 square feet of pavement tiles for the Great Rotunda and corridors of the new state capitol building in Harrisburg. Mercer set about designing subjects for approximately 400 mosaics. He chose as his general theme the history of Pennsylvania, and he soon realized that his tiles could tell stories. Although the arrangement seems random, the mosaics are very thoughtfully placed in the floor. The tile sequence is roughly chronological, beginning at one end with the scenes depicting the Native Americans. The mosaics progress into the story of European habitation in the New World and encompass the Commonwealth's triumph through process and intervention. Now you know.
I am Dr. Thomas Wyda, a family physician and professor of family and community medicine at the Penn State Hershey Medical Center and College of Medicine. I've been in practice for 25 years and am board certified in family medicine and geriatrics. I see a majority of patients who are over the age of 65 in my medical practice and appear today regarding the wisdom of increasing the mandatory retirement age of judges from 70 to 75. The essential concern of increasing the mandatory retirement age is the deterioration of cognitive functioning in the elderly. Sadly, we all reach our peak mental acuity at age 25. We're all over the hill, with a progressive decline from then. Brain volume shrinks beginning at age 30. But like most organs of the body, the brain also has tremendous reserve, so that this decline for most individuals is not functionally noticeable in old age or even advanced old age. According to a number of studies, the number of people over 65 with dementia compared to the population, known as the prevalence of dementia, increases with advancing age, ranging from 1.5% in the 65 to 69-year age group to about 3% in the 70 to 74-year age group. It approaches 6% in the 75 to 79-year age group. Therefore, even in advanced age, the prevalence of dementia, which can interfere with decision-making, is relatively small, particularly up until the age of 75. In animal studies, brain cells with advancing age can lose 45% of spiny dendrites, which are things that communicate with other neurons, and they're responsible for learning and remembering new things. However, the stubby dendrites, which are responsible for things which have been known for years, suffer no decline. Hence, new memories may be more difficult to retain with age, but knowledge and expertise remain intact, oftentimes well into the 80s. We all know individuals whose mental capabilities remain sound well into their 80s and 90s. I have a number of patients, 80 years of age in my practice, who are highly functional mentally and physically, participating on boards of directors and running businesses. Penn State's College of Medicine has no mandatory retirement age. In the world of medicine and its critical decision-making, individual functionality is favored over an arbitrary retirement age. Expertise trumps memorization of rote facts. Also, the Board of Medicine has no age at which a physician must relinquish his or her license. Medical licenses are revoked for performance issues, not after a predetermined age has been reached. As such, age cannot be the only factor affecting mental acuity and reasoning. Only about 20 to 25% of the variation among people in standard measures of memory, problem solving, and other executive functions is the result of age. The rest, 64 to 96% on different cognitive test scores, is the result of other factors. Factors which negatively affect mental abilities as one ages are low education status, genetic factors, high blood pressure, diabetes, hardening of the arteries, smoking, depression, head trauma, poor diet, and poor social networks. Americans are living longer, now with an average life expectancy of 78. Additionally, they're living healthier longer, which correlates with retained cognitive abilities. What improves mental acuity with age is the same thing that improves the body's overall functioning: aerobic exercise, such as brisk walking. 3 vigorous 40-minute walks a week over a 6-month period improved memory and reasoning, according to a study done at the University of Illinois. It also stimulated the birth of new brain neurons and increased the volume of white matter, which connects neurons in areas responsible for executive functions as planning. A Canadian study showed that use of non-steroidal anti-inflammatory drugs, such as ibuprofen or Aleve, wine consumption in moderation, not bad to hear, coffee consumption, also not bad to hear, and regular physical activity were associated with a reduced risk of Alzheimer's disease. A study by Bruce Campbell showed that adult cognitive development continues indefinitely in active learners, that college-degreed older adults who are actively engaged in learning use age-specific learning strategies, and that the benefits of late-life learning appear to be an antidote to aging. Studies show that individuals with higher levels of education have a lower prevalence of Alzheimer's disease. Other studies show that engaging in mentally stimulating activities decreases the prevalence of dementia, and that those elderly participating in daily mentally challenging activities show less decline on cognitive tests. As such, there's no evidence that a specific age denotes a significant deterioration of thinking and reasoning, which would interfere with the judicial decisions. There are already sufficient safeguards in the Pennsylvania Constitution and with the Pennsylvania Supreme Court to remove judges who are cognitively impaired, a condition which can occur at any age. Therefore, I see no medical evidence to prevent increasing the mandatory retirement ages for judges to 75. There's no sharp decline of mental functioning between 70 and 75. We should not lose valuable expertise and wisdom on the bench by forcing retirement of jurists at age 70. Advanced age does not equal and equate to advanced senility. Thank you.
Thank you very much for your testimony. The thing I like most about this job is that we get to learn new things all the time. We learned about spiny dendrites and stubby dendrites today. Does anybody have any questions for Dr. Wida? Representative Barbin?
I agree with you, and the only thing, can you point me in the right direction of this animal study, because I find that very, interesting, especially from the point of Alzheimer prevention.
I can get that information to the committee.
Thank you.
Thank you. Chairman Sabatino?
Doctor, I'm afraid this question is probably impossible to answer, but I'll ask it anyway. Is there an average age that humans do lose their mental capacity, I guess? I mean, I know it probably varies for everyone, but I was just wondering if there's any scientific study that predicts a downhill trajectory.
Right. The study that I referenced, where 1.5% have dementia at 60 to 65, et cetera, does show that for every 5 years, there seems to be a doubling of the rate of dementia. So I think that's about as close as you're going to get to that. So certainly, folks in the 90s, there's a higher rate of dementia in the 90s than there are in the 75. But each individual is different. My aunt is 91, and she's probably smarter than I am and remembers much more than I do at 91.
You've been watching portions of a hearing on my bill that would increase the mandatory retirement age for judges to age 75. And that's all the time we have for today's program. I'm State Representative Kate Harper. If you have questions about this bill or would like to track its progress, feel free to contact me at my local office or through my website. That information will be shown on your screen in just a moment. Thanks for watching. Please join me next time for Legislative Report.